Hi, this is Alex Koldowski. Welcome to the podcast series. I have a very special guest, Robert Finlay. He is one of three founding fathers of Wright, Finlay, and Zak. He is at the forefront of mortgage banking industry, handling all aspects of ever-changing default servicing, banking litigation arena, including compliance issues for servicers, lenders, investors, title companies, and foreclosure trustees. Robert, welcome to the podcast.
Thank you very much, Alex. I appreciate it. And thanks for your patience in getting this going. I know I had to reschedule a couple times, but we're here. And so I look forward to talking to you.
Yep, very good. So, Robert, let me just tell the audience why we're rescheduled, right? I actually read Robert's article about all the changes that our clients are facing in California. And I got in touch with Robert. I said, Robert, I got to get you on the podcast. We got to talk about things that's going on with this Moon case. And Robert said, no, I can't talk to you because it's still in litigation and I have to wrap up the case. And finally, the case was wrapped up, and Robert is freely able to talk about all the decisions and all the legal aspects that derived from the Moon case and other aspects that investors should know about for California note investing. So we're going to chat about, bankruptcies and allowable interests, modifications, and anything new related to California cases. So I wanted to start off, a very obvious thing, right? So let's talk about default interest rates in California and what's allowed. I think this Moon case dives right into the what's allowed to be charged by an investor in California.
Yeah. So actually, I think there's two issues I want to talk about, and I think we should talk about it. One is default interest, and that involves the Honsharu case that came down a year or so ago, and where we stand right now. And then we have the In Re Moon case, which also involves interest rates, but from a different angle, involving usury rates. And In Re Moon is the most recent one, so I think that's probably the one we should start with. But they both involve interest. So the In Re Moon decision involves usury interest in what can and can't be charged in California. And this applies to business purpose loans, construction loans, consumer loans, commercial loans, does not matter. In California, we have a usury cap of 10%. So you cannot charge interest over 10%. It's in the California Constitution. However, there are so many exemptions to that rule that it's almost where the exemptions have swallowed up the rule. So banks have an exemption, credit unions have an exemption, everyone has an exemption. But the one that comes up most commonly in the private lending space is real estate or loans that are arranged or negotiated by a licensed real estate broker. Those loans are exempt. So you could charge 12%, 15%, 20%. Obviously, you can't get too greedy because then you could get into conscionability issues. But as far as just a blanket usury rate of 10%, you can get past that by negotiating or arranging a loan via a licensed real estate broker. And that's what a lot of people in the private lending space do, and just in the lending space in general. So where In Re Moon came in is you had a loan that was exempt from the usury threshold. The interest rate was 11.3%. And the Moons fell into default, and they worked out a extension, modification, or forbearance. They call it a settlement agreement. You can call it any of those things. But they worked out this agreement whereby the interest rate would actually be dropped from 11.3 down to 11.05. So it benefits the consumer, benefits the borrower, all good. There's some other terms that were tweaked, but for our purposes, that's what matters. The Moons defaulted again. They end up in litigation with their lender, and they end up in bankruptcy court. And one of the issues that came up at the bank, it went to the bankruptcy court, who then issued a decision negatively, which then went to the bankruptcy appellate panel, which was upheld. And those bankruptcy decisions, the combo between the bankruptcy court and the bankruptcy appellate panel, made several rulings, but the ones that are relevant to us is that, number one, the lender had argued that, the usury exemption that was because the loan was originally negotiated by a licensed real estate broker, that carries with it through the life of the loan. So once it was exempt to begin with, it doesn't matter later on, the exemption continues. And the court said, no, that's not the case. And that's not what the statute says. It said that if you're going to do a forbearance, then the forbearance has to be negotiated or arranged by a licensed real estate broker. The lender also argued that, well, this was actually a settlement agreement. It wasn't a forbearance. And the court said, no, you can call it a settlement agreement, but it's still a forbearance. And one of the issues that's a little tricky there is that in the applicable statute, it just says, it says a forbearance must be negotiated or arranged by a licensed real estate broker. It doesn't tell us what a forbearance is. It doesn't define it. So then we look to the standard definition of a forbearance in the context of the mortgage world, and it is to forbear, to hold off from collecting on your debt. So that could be just about anything. That could be postponing your foreclosure sale, modifying your loan, changing the interest rate, just holding off from foreclosing. So in the Moon case, the court said, well, no, just because you call it a settlement agreement, that that doesn't matter. It's still a forbearance. Okay, so they strike two there. And then the third, the lender argued that, well, one of the owners of the company was a licensed real estate broker, and therefore the broker exemption should apply. And the court said, no, first off, that particular owner didn't have anything to do with this loan whatsoever. So therefore, the loan was not negotiated, the forbearance was not negotiated or arranged by that licensed real estate broker. So strike three. And all that's fine because that was very narrow to the particular case that was involved. But then the bankruptcy decisions throughout, I think it was a footnote if I recall, footnote just said, oh, and by the way, even if that licensed real estate broker who happened to be an owner of the company was involved, it wouldn't matter because in order for the exemption to apply when you're doing a forbearance, the forbearance must not only be negotiated or arranged by a licensed real estate broker, but it must be negotiated or arranged by the licensed real estate broker who originally negotiated and arranged the loan. So you have to go back and use the original broker that was a part of the transaction. And that transaction had to be part of a sale or lease of the property. There's some other language where it could apply, but doesn't apply to our situation. So red, in its most conservative fashion, what the court was saying is that to do a forbearance, it needs to be negotiated or arranged by the original licensed real estate broker, and that transaction had to be part of the original purchase money transaction.
Okay, Robert. So based on what you're saying, we need to find, we mean servicer, needs to find an original broker, right, to sign the forbearance agreement, and that's not always the case. So what do you recommend for the servicers to do when right now they're between a rock and a hard plate, and they can't find the servicer, so the forbearance cannot be executed? Is that what the decision states?
Yeah, so I'll take one step back in that the matter went from bankruptcy appellate panel up to the Ninth Circuit Court of Appeals. The Ninth Circuit Court of Appeals issued a ruling, but it did not touch that issue of whether or not you need to have a licensed real estate, whether or not you need to have the original licensed real estate broker, and whether that needed to be part of a purchase money loan. And their decision was unpublished. So where that leaves us is in-rate movement is not really good case law anymore. But the theory behind it and its rationale is very much out there. So while an attorney that's representing borrowers can't cite to in-rate move, they could still cite to the underlying statute with that same theory. And so what we're seeing from a litigation end is we're seeing a lot of borrowers' attorneys file these lawsuits, claiming that somehow, the modification or the forbearance was not negotiated or arranged by the original real estate broker. and we're having problems with that litigation. So again, I just want to be clear that in Ray Moon, although it's been it's unpublished at this point in time, the rationale is still the problem. So back to your question, Alex, what do people do? So I have calls probably 2 to 3 times a week with servicers about what they want, what they can and can't do. And the answer is a lot of it depends on your pain threshold, your risk tolerance. If you're really conservative, then you really can't do a forbearance unless it was a purchase money loan, which is rare. Most of these are refinance. And you can go back and get that original licensed real estate broker to not just sign the forbearance, but to actually negotiate or arrange that forbearance agreement. That's the most conservative, safest approach.
Now, that's unrealistic, right, Robert? I mean, who would start looking for every broker or original real estate agent or broker, right, that would, negotiate and coordinate the execution of the mod? All right, Robert. So what do you recommend for the servicers to do, and for my clients that are hedge funds and investors on signing the mod, executing deferral agreements, or executing anything with the borrower based on that case law?
Yeah, so first off, keep in mind that only matters if your interest rate's over 10%. If your interest rate is under 10%, then this is not a concern of yours. And if you're a bank or your credit union, you have other exceptions. This is if your loan is over 10% and was negotiated or arranged by a licensed real estate broker. So in those situations, it depends on the client's risk threshold, their pay threshold, their risk tolerance. I have some clients who are saying, I'm not going to do any forbearances at all. I don't want to risk violating a law trying to help a borrower out. So that's one option. That's the most conservative option if you cannot go get the original broker and it was not a purchase money loan. Others are falling on still conservative, but not as conservative, which is, what if I don't touch the interest rate at all? So even though in the Moon case, the interest rate was actually dropped from 11.3 to 11.05, and that arguably benefited the borrower, there's a legal argument that we could make if you don't touch the interest rate at all. You just postponed your foreclosure sale. You just extended out the term of the loan. You just changed something else, but you didn't enter into so you didn't touch the interest rate. I don't know how that'll play out with the courts, but I think there's definitely a good, strong legal argument that because we never touched the interest rate, then the forbearance doesn't even bring into usury. I think that's a good argument. So some people fall on that side. Others are much more, I guess, less conservative, and they'll go ahead and change the interest rate, extend the terms, as long as they use a licensed real estate broker, they feel comfortable, and that what they're doing will get tested down the road. So it just depends on an investor's risk tolerance level when it comes to working out forbearances and modifications.
Hey, Robert. So let's touch on default interest rates. What can our clients charge in California? What's allowed?
Yeah, okay. So we're switching gears from the usury issue, and now we're switching over to default interest issue. And the default interest, historically, the standard for what you can and can't charge in California has always been, is there a reasonable relationship between the interest rate that you're charging and the anticipated loss that you thought you'd suffer at the time you originated the loan? And when I say loss, I don't mean reduction in value of the property or foreclosure fees and costs or anything like that. I mean loss of use of the money, potential intangible damages that you may suffer as a result of the default, such as sometimes it can affect your line of credit, your own administrative costs and time, anything that you're not otherwise going to recover through the foreclosure. You're showing that there's a reasonable relationship between the default interest that you're charging and that loss that you thought you were going to suffer in the event of a default. So that's always been the standard. Now, reasonable relationship, that doesn't really tell us a whole lot about what you can't, because what we all want is, no, can we charge 5%? Can we charge 7%? But that was the standard. That is the standard. That was set by our Supreme Court 100 plus years ago. It was always the burden of the borrower in the non-consumer context, because there's rarely you're charging default interest in a consumer on a consumer loan. It was always the borrower's burden to challenge the default interest. So we see default interest from a standpoint of an additional 4%, 5%. I've seen 15%, 20% on top of your note rate. So let's say your note rate is 10%, and your default interest is an extra 5%. You're now charging 15% upon that default. And there's been all sorts of court challenges over the years to whether or not 5% is okay, 7% is okay, 10% is okay, but there's never been a bright line rule. And then in September of 22, this case Honcharu came out. And Honcharu, the court basically said that anytime you charge default interest, no matter what the rate is, on the entire unpaid principal balance following a simple payment default, that is per se unreasonable. So before we would, again, borrower defaults on a payment, we charge default interest on the entire unpaid principal balance. That just has been the standard. That's what what lenders have been doing for decades. And as long as they didn't get too greedy, the borrower had to pay it. And if the borrower challenged it, it was upheld in court. But now, anytime you charge default interest on the entire unpaid principal balance following a payment default, that is per se a violation, and it's going to be unreasonable. And what that does let me take one step back. When I say any interest, it could be 0.1%, it could be 0.00002%. That's going to be unreasonable, which is ridiculous. The court drew this bright line rule, which is what's created so much upheaval in the commercial and private.
What's the worst case scenario for the client that's charging over the allowed interest rate? Are they nullifying the mortgage, or not as extreme, and they have to refile? What is the worst case scenario for the lender or the fund?
Yeah, great question. So I know that there are some lenders out there, there's some lawyers who have advised those lenders that go ahead and just charge the default interest, and if the borrower complains, then go ahead afterwards and just waive it. And I don't advise that way, because I think it's very risky. If you're demanding money that you're not entitled to, you are breaching the contract, which means they can sue you, and not just sue you for what they had to pay, the default interest, asking for it back, but they can sue you for other damages that they may have suffered as a result of you demanding money you're not entitled to. And then they're also entitled to their attorney's fees. So we have some cases where borrowers actually paid the default interest and then weeks later filed their lawsuit. And that attorney has a blank check in that lawsuit, because they know they're going to win. They know they're going to get the default interest. So they're shooting, for the moon, and to go back to the moon case, but they're shooting, they're shooting for everything, and they want all sorts of damages they may or may not get, but they are going to get back the default interest, and they're going to get their attorney's fees for having to sue you for it. So we don't recommend just demanding default interest and hope that the borrower doesn't know what's going on out there. This decision is well published, and it is final, and borrowers' attorneys and even borrowers know what's out there. So the risk is you get sued, and the risk is you're going to lose, and then there's attorney's fees and maybe damages on top of that.
That brings the next interesting question. In what cases you can charge the default interest rate? If you can go through some of the examples.
Yeah. So that's a question, again, we're still getting quite a bit today. What Honcharu said is you can't charge default interest on the entire unpaid principal balance. Okay. So that leaves a few options. Number one is, if the loan's matured, that's not a payment default. So the loan has fully matured. You can charge default interest on a matured loan. Second, you can charge default interest on the missed payment. So if the borrower had a $10,000 a month payment, while you can't charge default interest on the entire unpaid principal balance following a default, you can charge it on that payment, provided that your note allows for compound interest, which is an easy check to verify. I know that's not what lenders and investors want. They want to be able to use it to charge it on the entire unpaid principal balance, but at least you can do it on the missed payment. Next, and this is getting into some gray areas, is the Hunchru case dealt with a non-monetary default. So there's a theory out there that if there was Hunchru dealt with a monetary default. There's a theory out there that if there was a non-monetary default, that if you were to go ahead and send notice of default, and then the borrower doesn't cure, and then you send out a notice of acceleration, and in that notice of acceleration, make it very clear you're going to charge default interest, and then start charging default interest from the date of acceleration, the argument is that first, that Hunchru does not apply because it's not a monetary default. This is a non-monetary default. And number two is Hunchru didn't apply because there you didn't have a fully accelerated loan. But in the example I'm giving, you do have a fully accelerated loan, which is more akin to a matured loan. So there are some people that are doing that. That's depends again on your risk tolerance. So I walk lenders through this on a weekly basis, and some say, no way, I don't want to mess with it. I'm not going to charge default interest until the loan matures. Others will say, you know what, I'm going to go ahead and if this is a non-monetary default, I'm going to send out my notice of default. If that doesn't, when I say notice of default, I mean a notice to cure. And then I'm going to accelerate and then charge default interest for the date of acceleration. That's where their risk tolerance is. At the end of all of that, everything I've said, if you are charging default interest, it also has to be reasonable. At the end of the day, it still has to be reasonable. So don't get too greedy.
All right, great point, Robert. So next I wanted to touch on the litigation trends in California, effects in the elder cases, anything that you see our investors, servicers would need to worry about to make sure that they avoid any issues with the borrower or issues that will prevent for them to either foreclose on the property or execute correct documents. So give us a rundown of what you're looking at this year, last year, and what our clients would need to worry about.
Yeah, in the commercial construction and private lending space, the top two litigation issues we see are the user issue that we just talked about with In Re Moon, and the default interest issue in relation to the Hunchru case. So those are number 1 and 2. But there's 2 other trends that we're seeing a lot in the litigation. And the first one is elder abuse claims. And traditionally, when we think of elder abuse, we think of the 90-year-old woman who lacks capacity to sign the loan documents, and a unscrupulous lender goes out there and makes her a loan anyway. And the kids come back later and say, grandma or mom didn't have the capacity, she was losing it, and this loan is invalid. That's not the type of elder abuse I'm talking about now. California has an elder abuse statute, and the theory that is being laid out is that anytime you make a loan to an elder who is someone over 65 years old, so it's not grandma who's 90, anyone over 65, if you make them a loan and that loan is for a wrongful use or purpose, that you are taking an interest from that elder, you're taking an interest in that piece of property. Or if you buy the property at the foreclosure sale, you're taking an interest, you're taking the property from that elder. And the actual foreclosing on an elder is fine. You're allowed to do that. But if the loan itself was for a wrongful use, then the elder abuse statute comes in, which gives the borrower the option, or gives the borrower the right to cancel the loan, gives the borrower a right to sue for damages, gives them the right to attorney's fees. It creates a whole new area of exposure for lenders or foreclosure trustees or investors, all related to this elder abuse statute. And again, the legal theory that's been being thrown around out there, and one of the attorneys that was involved in this actually just prevailed at the trial court level on an 8-week trial up in the Bay Area, and we're seeing a lot of litigation from this attorney. But if the loan is not in the borrower's best interest, then it's therefore wrongful. And I think that's a gross exaggeration of what the statute is supposed to say and what was intended to say. But that's basically the theory that's out there. And it worked in that case, and it's causing problems in lots of other cases. So you want to be careful. I'm not saying don't ever lend to someone over 65, but you do want to be careful of the loans that you're buying where someone's over 65. And you want to make sure that, take a look at those loans and do some due diligence to make sure that the broker that you're buying those loans from, or the broker that brought you those loans, that this loan was in the borrower's best interest to the extent.
Can you give an
that
example of Robert, of the errors for the mistyping or misuse of those loans?
Yeah, so the case that's up in the Bay Area, we're not involved in, but we're actively watching on behalf of the industry. It involved two loans that were made to an elder up in the Oakland area, and the loans had high interest rates. They were they were written as business purpose loans, but the court determined that they were actually consumer loans. The loans did not help the borrower in that they put the borrower in a worse position than they were in before. The counter argument was that this borrower probably would have lost the houses, at least one of them, in foreclosure, but for the loan that she took out. So, but the court didn't seem to care about that. They had a very liberal judge, and the court basically said that these loans were not in the borrower's best interest, and that the borrower was taken advantage of. And the borrower was told to lie on about whether this was a business purpose or consumer loan. And therefore, it fell under the elder abuse statute because it was for a wrongful use. That's one example. Other examples that we've seen is where a borrower is on the verge of foreclosure, and a private lender comes in and gives them a loan to help the borrower save the property and not go to foreclosure sale. But then the borrower's attorney comes back later and argues that, well, that interest rate on that loan was higher than a normal consumer loan. Well, it was a private money loan. Of course, the interest rate's going to be higher. That the elder was, that again, it was actually a consumer loan and not a business purpose loan. But basically, the broker was not looking out for the borrower's best interest. But by the mere fact that the borrower is over 65, then loops in this elder abuse.
Interesting. So in essence, when lenders run a diligence before origination of the loan, they have to use a sort of a logical approach that the loan will help the elder in whatever purpose. Otherwise, they're running a risk of, misuse or sort of voiding that loan altogether.
Yes. And then the other area that this comes up where you want to be careful of is what these attorneys are doing is they often send a notice to the servicer and or the foreclosure trustee saying, we believe based on our investigation, this loan is the subject of elder abuse. And if you continue with the foreclosure or you take steps to foreclose, you yourself could be in violation of the elder abuse statutes as the trustee or as the servicer. So they're putting you on notice that on it. And what it creates a tricky situation there is, well, you don't know if what the attorney's saying is true. And of course, we've all seen attorneys make representations on behalf of borrowers that are not true. So you at that point in time, you'd want to stop and look at your loan. But even if you stop and look at your loan, you feel pretty good about it. Moving forward could increase your exposure or create exposure. So what we recommend is if you get one of these letters that specifically talks about elder abuse and you get it during your foreclosure, pre-foreclosure, you want to bring that to an attorney right away and have that attorney take a look at it. Part of it will depend on the attorney on the other side, whether they're credible, whether they're not credible, and then, of course, the specific circumstances around your loan. But you'd want to do a full audit of your loan before moving forward with that foreclosure.
Um, so in essence, and again, for everybody out there, Robert's firm did represent me. I'm super happy. They had a win for me, and I definitely recommend Robert's firm for any consultation on elder abuse or default interest rates or issues with the mod. Let's touch on enforcing guarantees. What's the latest legal issues, and what do my clients need to worry about?
Yeah, so we're seeing a huge uptick in enforcement actions on guarantees, and where this comes into play is in your construction loans or your commercial loans or your private lending loans. You're often making those loans to LLCs or businesses, and those businesses may or may not have a lot of assets above and beyond that particular piece of property. Classic example is your fix and flip loan. You make it to a single asset LLC who only owns one thing, which is the property. But then if you're originating it correctly, you generally would want to get a guarantee from the owner of the individual who is behind that LLC. So you get your guarantee from that particular person. That way, if a fix and flip project goes underwater with interest rates rising or with property values dropping, goes underwater, and they decide to walk away, then there's recourse for the person behind the LLC. Because you can't, in California, you can't get a deficiency judgment, generally speaking. And even if you did against an LLC, it's probably not going to have much value. But that individual behind the scenes who owns several houses or, owns the house free and clear, who's been, making money hand over foot over the years with different projects, having a guarantee against them is key. So in order to enforce that guarantee, what you want to do is, number one is we send a demand letter to the guarantor. We generally recommend sending it pre-foreclosure. At the same time, you're sending your notice of intent to foreclose letters on that LLC. So now what you're telling the guarantor is, hey, not only are we going to foreclose if you don't bring this current, but we are also going to go ahead and sue you personally under the guarantee. You may still end up completing your foreclosure, and you may not, and you may hold off suing the guarantor until you figure out how much of a loss you've actually suffered as after the foreclosure and after the resale of the property. Or you might go ahead and, because you're going to suffer something, and you might go ahead and sue the guarantor directly at the same time you foreclose. What that does for you is it gives you a lot of leverage. And what we find that when you file that lawsuit, even though you plan on going through with it, to recover your losses, we find that it ends up bringing the guarantor to the table. And what we do is we end up working out some sort of deal. The deal may look like, okay, the property is worth $1 million, but the loan is $1.5 million at this point, and you get the guarantor to kick in $200,000 or $300,000. So you get a deed in lieu, and you get $300,000, which is more than you'd get if you just went ahead and foreclosed. So you get the property and a little bit of cash. That's one way we see these deals working themselves out. The other way is sometimes we end up adding extra collateral. So we'll add a lien on somebody's house, a second lien, where there's sufficient equity, or maybe there's another project that has a lot of equity in it, and we'll add a lien on that. So that's another area that we see solutions to the underlying default. Whereas if you're just foreclosing on LLC, you don't have those options. And then in some situations, we have to go ahead and complete the lawsuit against the guarantor. We get a judgment, and then we go ahead and collect it against the guarantor for whatever we're owed against whatever assets they may have. So that's what we're seeing. Just a lot more use of the guarantee. I will say that how your guarantee is written will affect what we can and can't do. So, happy to take a look at your guarantee and say, okay, well, you're going to need to non-judicially foreclose first in this situation, or in this other situation. If you have the right language in there, you don't have to. Which then brings me to a related point, which is if you're making loans and you are including a guarantee, make sure that it is a well-written guarantee that gives you all the options, the best options available to you, and which we're happy to help you with. The other thing I recommend is that make sure the person that's signing the guarantee has some assets, because otherwise it's worthless. When you're originating that loan, Or if you're doing a modification later on in some way, shape, or form, the borrower is your friend and they want to cooperate, and they're willing to cooperate because you're giving them something, the loan or a modification. So that's a great time to add or ask for their financial to find out what assets they actually have. And that makes our job easier when it comes to collecting. So in origination, you say, all right, I'm going to make you this loan. We're going to require a guarantee, but what assets do you have to make that guarantee worthwhile? And more likely than not, they'll be happy to show you the house they have in Palm Springs, or the house they have in Big Bear, or whatever it might be. And then at least you know that there's property. Doesn't prevent them from transferring it later, but at least you know what they had at that time. Then later, when you're doing a modification, keep this in mind. Number one is, if you don't have a guarantee and you're doing a modification with a business, that's a great time to ask for a guarantee after the fact later, number one. Number two is, if you have a guarantee, that's a great time to ask for their financials again to see what assets they have. And that might help you decide whether you do want to do a forbearance or a modification at all. And then if you are going to do it, it also helps you know what assets they have at that point. And then lastly is, if you're doing a modification or forbearance or anything like that, make sure you have the guarantor also sign off on it.
Robert, this is great advice for the investors in California. Now, I'll give you an opportunity to tell my clients, the investors, about your firm, how you can help them in California specifically.
Yeah, no, thanks. And the issues that we just talked about are some of the common issues that we're helping investors and servicers with every day. But in general, we help our clients with any sort of litigation involving a loan or a piece of property, whether it's borrower-related, generally borrower-related litigation, but also title-related litigation, complex bankruptcies and evictions. And it's not just in California. I'm in California. That's our main state. But we also have attorneys in Washington, Oregon, Nevada, Arizona, and then remotely cover most of the western states, including Hawaii, Montana, Idaho, New Mexico, and South Dakota. So kind of a Western regional firm, and our niche is representing people in the mortgage space. So thank you.
Yeah, Robert, once again, I wanted to thank you for coming on to the podcast. A wealth of information. Folks, if you have issues in those states, come knock at Robert's door. He helped me. That's why I am having here Robert to tell about his firm. His staff is great, phenomenal. They helped me out quite a bit. Again, Robert, thanks again. And I will look forward to seeing you at the next conference.
All right. Thank you very much, Alex. Have a great day. Bye, everyone.
You too. Take care. Bye.